Now, if it's an adult and they've been drinking too much, they're intoxicated, the police, most of the time, when they learn of the intoxication, are going to take blood alcohol tests of some form or another, whether it's breath, whether it's urine, whether it's blood. They're going to take these tests. Even if the person's been hurt and has been taken to the hospital, the police can require that there be blood draws, and they learn how much alcohol is in the person's system.
When they do that, what does that mean?
Normally, you can extrapolate back. You can learn when the accident happened. You can learn what the alcohol test was. If you note, when it's been an injury accident, the police will take a number of tests over a period of time so you can learn whether or not the alcohol was having a greater or less effect from the time of the accident to when you have the test.
Right, so if you get a blood alcohol level at reasonably close to the time of an accident, do you mean to tell me that you can back up in time to place this adult in a bar and you can figure out what their blood alcohol level was in the bar before they left?
Absolutely. But you have to be able to track that. One of the problems you face almost immediately is where were they drinking? A lot of people who drink have favorite watering holes, as they call them, and you don't get to learn where they're drinking because they're not going to tell you. You have to wait, again, till you can sue them, till you can get them in a deposition. Well, our law says you have 1 year from the time of the accident to sue the establishment that got them drunk. And if that establishment overserved them and served them when they were aware of the fact that person was drunk or should have known by either the number of drinks they were giving that person throughout a time period or by how they had to have been acting according to their blood alcohol level, if that establishment was doing that, they can be held responsible.
So the bar can be held liable?
Absolutely, for the injuries and sometimes for even more than just.
And so sometimes in these cases when the injured person, if they're still alive, has hundreds of thousands of dollars in medical bills, has been very seriously injured, and the drunk driver only has $25,000 of insurance, you mean then you can possibly go against the insurance company for the bar who served the drunk driver?
Yes, you can. And quite often in these type cases, because it's involved drunk driving, you have very significant and severe injuries.
But you know, Brad, sometimes they say the bartenders, we've deposed them, you've been there, I've been there, we've done them together. The bartenders say, it didn't look strange to me. I didn't know he was visibly intoxicated. Sometimes they just lie.
In this day and age, we have a couple of things that work. Many systems in the bars, they're called Aloha systems, they're called systems where you know how many drinks were given to that person over the time period they were in the bar. They open up a tab, you can go back to the tab. Sometimes you need to get a credit card to see if it was paid on the credit card. Other times you can just find out according to the table they were sitting at or according to the name they were given how much alcohol was given to them. If you find somebody's been given 4 drinks in a half an hour before they walked out that bar, that's 4 shots in a half an hour. Chances are the bartender has overserved. If it's 8 drinks, you know they've overserved. Take it the other way. If you find out that person's been sitting there for 3 or 4 hours, but during that time period they've had nothing to eat because their tab doesn't show it, and at the same time they've been served 12, 13, 14 drinks, you know what their condition would have been. They would have been slurring their words. They would have been having bloodshot eyes. They would have been fumbling for their billfold. They would have probably gotten very loud, abnormally loud, or they would have gotten abnormally reserved because alcohol has those effects.
And one of the proofs is you have to prove that the bartender or the bar served them while they were visibly intoxicated, but the person, the drunk driver, always denies they were visibly intoxicated. The bar always denies they were acting strange or loud or visibly intoxicated. What do you do?
Most drunk drivers are going to deny they were drunk. They're going to deny they were visibly intoxicated. The servers are going to say that, but once again, in our state, we have rules that servers are supposed to be trained. They're supposed to be trained to be able to identify and see the characteristics of somebody who's been overserved or is visibly intoxicated. Even if that person just walked into your bar. It doesn't matter. If it's 1 o'clock or midnight or 11 o'clock and the person comes in from having been drinking down the street and they walk in and they're too drunk or they're drunk at all, you're not to serve them. And if you do serve them and they're visibly intoxicated, you're going to have some responsibilities. And that's why we get the toxicologists involved. We figure out from the test what amount of alcohol that person had to have had when they came into your bar and when they left your bar. And a lot of times, even if we can't find the ticket, we can extrapolate how many drinks they were served.
Okay, let's just take an example for everybody in this virtual injury seminar we're doing. Let's say at the scene of an accident, somebody has a 0.31 blood alcohol level.
How long have they been on the road? If they've been on the road, usually at a 0.31, they're not on the road very long before they're in their accident.
Right.
Okay.
0.31. So they say they left bar ABC 2 hours ago, and you can, through a use of a toxicologist, can you back that up to see what their blood alcohol level was at the bar?
Sure, because what you do is you find out when they stopped drinking. It's not just when they left the bar, when did they stop drinking? And that's one of the questions that needs to be asked of them. Because were you drinking while you were in the car? Does the car have a bunch of alcohol containers in it? Does it have nothing? If they quit drinking 2 hours ago and they're at a 0.31, their blood alcohol level was higher when they left that bar. And if they had their last drink at that particular bar, that bar is going to have a problem because their blood alcohol level, we're talking almost 4 times the legal limit at the 0.31.
So no matter what the bar says he wasn't visibly intoxicated, no matter what the waiter or waitress says, no matter what the drunk driver says, you can prove their blood alcohol level in the bar, and you can prove they were visibly intoxicated with that blood alcohol level.
Absolutely. Very important, because it's going to provide over $200,000 more of insurance dollars if the bar has the basic package of insurance that's going to be available for your injured person. And when your injured person has been hit head on by this drunk driver and is laying in a hospital and has significant permanent impairment for years to come, it's going to be important to find as many dollars as are available to protect and help that injured person.
So you can look for coverage through the drunk driver's insurance company. You can look for coverage through the bar.
That's right.
Or source of the liquor. And you can also look for coverage through UM coverage.
And you look for your own UM coverage, which we've talked about. Underinsured motorist coverage, or if there's no insurance by the drunk driver, your uninsured motorist coverage, which we talk about in another segment. We talk about the fact it's important for you to have as high of limits as possible. Get what we call an umbrella coverage, or excess coverage, which is a coverage that covers you even in addition to your basic minimum car insurance policy. That coverage can be as high as $1 million or more dollars, and you're going to need every dime of it. Another thing to be aware of, if it's a loved one who's died on those roads, on the streets, at the hands of a drunk driver, there's a very, very good chance that you're going to have what's called a felonious killing. And when you have a felonious killing, even if they're not charged with a felony, you have what's called a felonious killing, and that removes the non-economic caps, which is a whole nother area of law, but basically in the state of Colorado, we have caps or limits as to how much money you can recover for non-economic injuries. But if it's been a felonious killing, somebody who's acted recklessly is being charged with a vehicular homicide or reckless homicide, those caps get removed, and now you can recover the full and complete amount that a jury or a judge might determine is an appropriate amount.